More than 2 million federal employees work on behalf of the American people. They care for veterans, enforce the law, ensure the safety and quality of our food and drinking water, conduct scientific research, and repair our warfighting equipment, among many other important tasks on behalf of the American people. They're also represented, in many cases, by unions, because Congress determined by law that giving federal workers the right to join unions and bargain collectively over their conditions of employment was in the public interest. In fact, that law states, and I quote, "The statutory protection of the right of employees to organize, bargain collectively, and participate through labor organizations of their own choosing in decisions which affect them safeguards the public's interests, contributes to the effective conduct of public business, and facilitates and encourages the amicable settlement of disputes between employees and their employers involving conditions of employment." Congress created the Federal Labor Relations Authority to administer, interpret, and enforce the system of labor management relations. The FLRA is part judicial, with a 3-member authority, and part enforcement agency with its Office of General Counsel, and part arbitrator with its Federal Service Impasse Panel. Under the law, the FLRA shall provide leadership in establishing policies and guidance relating to the system of labor management relations that Congress established in law. Today, this subcommittee, the Subcommittee on Government Operations, will examine the Trump administration's leadership of this small but very powerful and influential agency and the consequences of the practices and operations on our system of labor management relations. The Trump administration has made no attempt to disguise its hostility toward collective bargaining, unions, and federal service labor law. But 1 year ago, President Trump issued 3 sweeping executive orders that stripped employees, including whistleblowers, of union representation at grievance proceedings, physically expelled unions from federal offices, and imposed dramatic cuts to the ability of federal employees to represent their coworkers on work time known as official time. A federal judge struck down key provisions of those executive orders, finding that they were, quote, "an improper exercise of the President's statutory authority," and illegally conflicted with the rights, duties, and procedures that Congress had established in law decades earlier. The judge also wrote that many of the challenged provisions of the orders at issue were here effectively reduce the scope of the right to bargain collectively, as Congress has crafted it, or it impairs the ability of agency officials to bargain in good faith, as Congress in law has directed. Much like the President who appointed this chairman, the FLRA chairman has exhibited unprecedented anti-union bias. Chairman Kiko decertified the federal employee union that has represented employees at the FLRA since 1980. No previous chairman in the history of the FLRA under any administration of either political party has ever done that or presumed to do it. This single act reveals, I think, a personal and disqualifying anti-union bias. The explanation for this blatantly anti-union decision is at odds with the Department of Justice's Office of Legal Counsel guidance, which characterized the position taken as unreasonable. As a judge, Chairman Kiko and the other Republican authority members have disregarded longstanding Supreme Court precedents and, in my view, violated the FLRA's own regulations to rule against the unions. Persistent vacancies in the top position in the FLRA's Office of General Counsel have also allowed a backlog of more than 200 documented violations of federal labor law to go unaddressed or unresolved. As a manager, Chairman Kiko has earned a failing grade from the employees of the authority itself. According to the Partnership for Public Services analysis of OPM's Federal Employee Viewpoint Survey, employee engagement during Chairman Kiko's tenure fell 31 points in 1 year, from 2017 to 2018, a drop more precipitous than any other agency measured and of any small agency. I also have serious concerns about the reliability of representations made to Congress. In a March 2018 letter, Chairman Kiko told Congress that her reorganization of the regional offices of FLRA, which closed offices in Boston and Dallas, would increase the number of agents and have almost no net impact on staffing. In fact, those decisions led to a 21% cut in staff and placed unreasonable burdens on remaining employees. Chairman Kiko's statutory interpretation is, as the Office of Legal Counsel said, unreasonable. It contradicts and disregards long-standing precedent. The anti-union bias seems to be present, if not extreme. The agency she leads has not prosecuted a single violation since 2017, and her mismanagement has demoralized and dismantled the capacity of the principal enforcement agency of federal service law. 40 years ago, Congress codified collective bargaining rights and labor management practices as a critical component of civil service reform to foster an effective, merit-based federal workforce. Congress, and in particular this committee and subcommittee, will continue to value and protect those rights. I look forward to this hearing as an opportunity to put the administration and the FLRA chairman on notice. With that, I yield to the distinguished ranking member, my friend from North Carolina, Mr. Meadows.